Hello, and welcome to Study Smart, Not Hard. Tips, tricks, and strategies for getting through law school with a bit more ease and efficiency. First off, congratulations. You've worked hard, kept your grades up, and gotten to law school. These are exciting times. Whether you're a mature student returning to school after some time living life, fresh out of high school and just starting your undergrad, or a postgrad student starting your Juris Doctor, this next chapter of your studies will come with some new challenges. Learning the law is not like studying anything else, and it takes new approaches to get through it with success. Before you started this new adventure, you may have heard some rumors, talked to friends, and done some research online to understand what to expect. What your research has shown you is that law school is exciting, but it can also be stressful. And you aren't wrong. It's been clinically shown that stress lowers a person's IQ in the moment. You ever remember really knowing your stuff and being prepared and then blanking out during a stressful moment? That is a stress response that's happened to all of us. While we can't totally eliminate stress, developing the wrong coping strategies can make the stress response worse and spell trouble for your subjects or law school in general. Statistics show that 25% of students that enroll in law school don't finish. That's 1 in 4 students. So how do we make sure we don't become that statistic? It's definitely a fact that getting through law school is a complex process. You have to learn how to do legal research, read lots of long, drawn-out passages in textbooks, parse through case law and legislation, and distill the important stuff. This can seem dry and boring. You have to attend lectures, listen and take notes, understand complex systems, remember principles, legal tests and cases. You have to attend tutorials and make oral arguments. You have to learn legal jargon, full of old languages, complicated words, and different specialized definitions for words you may already know. Things like negligence, duty of care, principles of fundamental justice, legal ratios, ethics, the rule of law, exclusive possession, mens rea, evidentiary burden, and persuasive burden, among others. You have to learn and do well in different law subjects like torts, contracts, foundations, administrative law, criminal law, constitutional law, global law, business law, and then argue your position in tutorials or seminars or in an exam. Law school is expensive. Each course is in excess of $4,000. Whether you have a student loan, you're working to pay for it, or your parents were kind enough to help you with the money, I'm sure you want to pass all your courses with flying colors and graduate. It's challenging. You need dedication, hard work, and focus to make all this worthwhile. So there's a lot riding on this. It is stressful, but clearly you're up for that challenge. So is there a way to work smarter and mitigate some of the stress? Are there some tips, tricks, and strategies for getting through your law degree with a bit more ease and confidence? Hi, my name is Ron Janjua. I'm an international lawyer, academic, and lecturer in law at Griffith University in Queensland, Australia. I've also practiced in Canada and Australia and advised high-level clients and worked on some very complex matters. I've also successfully made it through a lot of education, including an Honours BA in International Politics and Economy, a Master's of Science in International Relations, a Juris Doctor in Law, and a Master's of Law specializing in natural resource extraction. So I had to develop efficient, repeatable strategies to get through my subjects with success. I also teach across a wide range of law subjects, including administrative law, constitutional law, property law, criminal law, foundations of law, and global law. While designing law courses and teaching law for 6 years to students like yourself, I've also learned the teaching systems side. I made connections and noticed patterns to refine the study process I'm going to share with you here. I've shared these strategies in class with lots of my students, and many of them have experienced a direct lift in grades and increased confidence across their law subjects. So if you're still with me, then I hope this video will help you do the same. Over the next 10 minutes or so, I'm going to talk about 3 strategies and how they fit together into a system that you can use to excel at law school and train your mind to become a lawyer. The first is a funnel method. What is it? Why is it important to think about it when you're doing your readings, attending lectures, and engaging in seminars? The second is IRAC, an easy to remember, powerful acronym that will give you a logical process to go through when thinking about and analyzing a legal problem, and how to efficiently answer legal questions by arguing in the language of the law. The third is to take what you've learned and turn it into a database and summaries so your cases, legislation, and tests are organized and easily accessible for exams. Are you ready? Let's get started. Let's start with the funnel method. University course elements are logically designed, assembled, and timed to help you absorb the information long term. Readings, lectures, seminars, tutorials, tests, and exams aren't held or assigned at random. These elements are all connected to teach you in gradual steps where the information is slowly concentrated and distilled, sort of like a funnel, with lots of information going in at the top and a concentration of knowledge coming out of the bottom. Once you understand why it's designed this way, you can start to think about using that knowledge to make your learning more efficient. So let's take a look at this process. Let's start with the top of the funnel. This is where all that information starts getting pushed into your head. It's sort of like a one-way information dump. You read and research, you read your texts, you read your cases, you read your legislation. Your mind will form questions, some will get answered, and some will be lingering. But it's important to do this. The middle of the funnel is where you listen and distill all that information that you started to read. Here you'll attend lectures. Your lecture will distill concepts in your assigned readings and narrow the focus on important issues, applicable rules, and methods of analysis. They'll discuss legal issues or rules to be focused on that week, and identify and discuss the cases that apply to these issues. They'll discuss the legal test or analysis. They'll identify and pinpoint the legislative sections that apply to these issues as well. Here you should take notes, identify the cases and legislation that applies, and add them to your rules database, which is to be discussed later. After lecture, you should also make case summaries, which include a case name, brief description of the facts, and any legal tests that come out of the cases, and the rulings that the bench made and the related issue that it's connected to. I'll explain why this is important later. They say that theory is useless without practice. This is where the tip of the funnel comes in. It's where you try, practice, and distill. So before your tutorial, you should test your ability to apply the analysis you learned from your readings and your lectures to answer a sample problem using IRAC, which I'll discuss later. You aren't expected to be perfect. It's your first attempt. You're likely to make mistakes, but trying is important. It's sort of like learning how to walk before you can run. You should then attend seminar with your tutor and your classmates and engage in the discussion of the analysis. Discuss your attempt at solving the problem to practice. Your tutor will help guide you through the process and may offer a model answer. This will help you to practice speaking and making legal arguments as well. Listen to your tutor, ask questions for more clarity, and learn from your colleagues to distill your notes and get a model answer. Your model answer will then become your step-by-step formula on how to analyze the problem. Keep this as a summary of the week's legal issues and analysis. There's one more thing I should mention. Each course builds on itself as it goes through the year. Each week will teach you how to analyze a particular legal issue. So each week also serves as practice for being able to successfully demonstrate that you understood that topic and can apply that knowledge when it comes to exam time. So if you follow the funnel method, read, listen, organize, practice, and mix it in with what comes next in this video, you'll have more confidence, be less stressed, and do better on your exams. All right, let's move on to using that powerful little acronym I told you about earlier called IRAC. Remember I said you need to apply legal issues you learned in lecture and reading to practice analyzing your sample problems? Well, legal analysis and answering questions is formulaic, and using IRAC goes a long way to learning how to thoroughly and succinctly answer a legal question. IRAC stands for Issue, Rules, Application, and Conclusion. Let's start with Issue. This is where you read the task and understand who you're being asked to advise. You read the fact pattern, identify the actors, and focus on the timeline and actions. This is where you would circle and highlight things. Spot the legal issues in the fact pattern or problem you're being asked to analyze. Sometimes just one, often several. For example, did John assault Peter? Were there issues of self-defense? Next is rules. This is where you identify the applicable legal rules based on the issues identified. Here's a hint. These are the rules that govern the legal issues that you read on and the lecturer focused on. This is where your reading your legislation and your case summaries and lecture notes will come in handy. And finally, it's application and conclusion. This is where you start writing out your answer and apply the legislation, cases, and tests to the situation. It's where you pinpoint your sources, argue from the perspective of your client, maximize your position and weaken the opposition's case, and where you provide a clear answer by building up your reasoning using legal tests. Don't just jump to the final answer. It's like math. You have to show how you got to the answer using logic and reasoning. And definitely don't regurgitate the law by reciting it. You must apply it to the facts. Now, before I move on to an example of how to use IRAC, I wanted to explain why I have the issue and rules in blue and application and conclusion in red. This is because you should read and organize your thoughts and make notes in the blue area, and then write your actual analysis in the red. Now that I've explained IRAC, let's look at a simplified fact pattern example from criminal law to apply it. John and Peter get into an argument after a few drinks. Peter, who is quite drunk, takes a swing at John with his fist. John ducks and avoids the punch. Peter takes another swing, misses again. Then John counters and lands a punch on Peter's face. Peter falls down. The bartender calls the police and they arrive shortly afterwards. They interview witnesses and John is arrested for assault under Section 245 of the Criminal Code. You are to represent John and advise on whether in fact he did assault Peter, and if he has a valid defense against assault. The first thing we should do is distill the facts. Peter took 2 swings at John and missed. John hit Peter and Peter fell. John is charged with assault. The issues that would be relevant here are the following. Did John assault Peter? Did Peter assault John? And does John have a defense at law? Now let's take a look at the rules governing this issue. The definition for assault is under Section 245 sub 1 of the Criminal Code. A person who strikes, touches, or moves, or otherwise applies force of any kind to the person of another, either directly or indirectly, without the other person's consent, is said to have assaulted that person, and the act is called an assault. Section 246 of the Criminal Code then goes on to say, an assault is unlawful and constitutes an offense unless it is authorized, justified, or excused at law. Well, that bit of law seems to offer us some guidance. Since we've been asked for applicable defenses against assault, we need to look further. And if we look at Section 271 of the Criminal Code, it says that when a person is unlawfully assaulted and has not provoked the assault, it is lawful for the person to use such force to the assailant that is reasonably necessary to make an effectual defense against the assault, if the force is not intended or is not such as likely to cause death or grievous bodily harm. To rely on this defense, John must not have provoked Peter, and his punch cannot have caused GBH or death to Peter. So let's put it all together now. Here's some follow-up questions and thoughts before we formally apply and conclude. It seems John definitely assaulted Peter based on Section 245 sub 1 of the Criminal Code by punching him without his consent. Since John is looking at self-defense, we need to see if Peter unlawfully assaulted John as well. It seems Peter also satisfies the definition of assault since he attempted to assault John without his consent by swinging at him. Nothing on the facts says that John angered Peter, so it seems that John can use Section 271 sub 1 of the Code as long as he doesn't go too far. A formal application and conclusion. The aim here is to try to be as succinct as possible while applying the law to the facts. That's what I'm going to try to do. Here goes. John struck Peter directly without Peter's consent and therefore has committed assault according to Section 245 of the Criminal Code, and it will be unlawful for John to do this according to Section 246 unless he can show he has an available defense at law. John seems to have a defense under Section 271 because Peter threatened to unlawfully apply force to John by swinging at him and therefore also committed the act of assault under Section 245 and 246. John's one return hit on Peter was reasonably necessary as a defense since it was not likely to cause GBH or death, so he satisfied the criteria for lawfully defending himself against Peter's assault and will not be found guilty. And there you have it. Notice how I did not regurgitate the law when I applied and concluded? I applied the law to the facts and came to a well-reasoned, logical conclusion. You might be wondering, does IRAC work outside the criminal law? Well, the answer is yes. It's handy for analyzing legal problems in every subject through law school. As long as you follow the funnel method and apply the IRAC steps, you'll be on the right path, whether it's foundations, property law, or constitutional law. And don't worry, this is all new and we don't expect you to be perfect out the gate. Applying IRAC properly to get a well-argued, concise answer will take practice. At least now you know the basics of the process, so at least you will be familiar on how to get started. If you attempted tutorial questions or practice exams using the IRAC method, and attend tutorials and class discussions to see if you have it right, and then shore up your answers, you'll get the hang of it and become better at every step. This will build confidence and lower your stress levels when it comes time to write your exams. Remember when I mentioned you're going to have to do a lot of reading, including cases, legislation, textbooks, and so on? I wasn't joking. Each law subject has hundreds of different cases, sections of law, and legal tests. You can't realistically memorize it all. Arguing the law does not mean memorizing it. In fact, lawyers don't memorize the law because legal reasoning is complex, involves applying case law and legislation, and the law is always changing. Lawyers do become good at quickly finding the rules that apply to their client's legal problem, so they can perform the analysis. Each law subject leads up to a final exam. On your exam, you won't have the time to thumb through your textbook and find the answers. You will be short on time and will need to spot your legal issues quickly and then identify the rules and start applying them and arguing your conclusion. So the trick is to be able to spot the issues and then know where to find the rules, how to read them, and then apply them to the facts to get the answers. In real life, you may not be short on time to do the research, but on an exam, you won't have the time to go looking through thick books, read whole cases, or scour through long wordy legislation. So the last strategy is to work on summarizing the things you learn and databasing the applicable law that you were taught, so you can bring it into your exams, access it quickly for the IRAC process, and then write your answers. Let's move on to summarizing and databasing. You should save your model answers at the end of every tutorial. I've already covered why this is important, so I won't spend more time on it in this part of the video. The second thing you should do is read your cases and write summaries. The third thing is build a rules database organized on issues from the very start of class. All this will help you with analyzing with IRAC. Case summaries are a brief explanation of the case. This includes the name of the case, the parties in the case, a brief explanation of the facts, the judge's IRAC analysis of the facts, the judge's ruling, which is called the ratio, and sometimes the dissenting judge's opinions. I don't have time to detail how to summarize a case in this video, but there are lots of examples of how to write a case summary. If you're curious, you can always start with a Google search on the case you want to summarize. You'll likely find one on a case being taught in law school, and you can use it as a precedent to do your own. You should summarize every case that your lecturer focuses on so you become familiar with the facts and the decision. Here's an important hint. Tutorial samples and exam problems are often based on cases you would have learned through the semester. So if you know the case that inspired the question, you'll also be able to spot the issues and apply the law that much faster. Let's talk about databasing your case law and legislation. If you do this, you'll have all the rules organized and very accessible during your exam for a quick look and cross-referencing. You won't have to rely on your memory or spending time leafing through your notes or textbooks. When you combine this database with your weekly summaries that are gathered by following the funnel method, you'll quickly be able to start writing and applying the relevant cases and sections of the legislation and can spend more time thinking of the analysis instead of frantically trying to remember what rules and legal tests apply to the issues you've identified. Your database can be built using Excel spreadsheets. Here's a screenshot example of one that I've used and recommended to students. Using Excel, open up a new spreadsheet and name it based on your subject. At the bottom of that sheet, add an extra tab. The first tab should be named Case Law, and the second tab should be named Legislation. So let's start on the first Case Law tab. Across the top row, label the cells as follows: Issue, Case Name, Facts, Ratio, Test, and Related Legislation. Across the top of the legislation sheet, label the cells as follows: Issue, Legislation, Name of Section, Section Subsection, Test, and Related Cases. You should save this file to your computer. If you start filling this in at the start of your subject, by the end of it you'll be able to print it out and take it into your exams as a quick cross-reference research database that will supplement your weekly summaries. That way you won't miss any of the law related to the issues you spot on the exam when you're writing your IRAC determined answer. Imagine walking to your exam with 2 sheets of cases and legislation, quick weekly summaries and answer formulae, and case summaries that you created yourself. First, you'll know the information really well. The second thing is, if you get stressed and forget something, you'll have it right in front of you, and you won't have to frantically go through your textbook or legislation. Instead, you'll be able to start issue spotting and then write your well-argued, well-cited answer with confidence. So in conclusion, we've gone through how law subjects are taught, and I've given you strategies and a formula to help you stay organized and focus on what's important, and to make your studying more efficient and successful, all while lowering your stress. By using your tools, your law subjects will become clearer, your grades will get better, and you'll become more confident, and you'll make an impression on your instructors. So don't forget, use the funnel method. Read, listen, distill, and practice. Apply IRAC. Build weekly summaries on your lectures and tutorials. Write case summaries, and build your rules database. If you employ these strategies, you'll get better. Your grades will lift, and you'll avoid being one of those statistics I mentioned earlier. Thanks for watching. If you like this video, feel free to share it with your law school colleagues or anyone else thinking about going to law school. And please click like on the video. Cheers and bye.